there could not be anyone who can explain things in a subtle manner and in a simplified manner. The overview of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989 has traversed through various judgments as well as, I would say, law. To that effect, how it has traveled and how is the legal journey, and what is the scope within the bails, criminal law, and all other aspects is a topic which we all know that when there is Mr. S.R. Somasekhara, a former district judge, principal district judge from Bengaluru, is the best thing to be understood. And we know that despite his busy schedule with the academy and his passion for taking academics, we always keep on pressing with him, and he's always kind enough to take time for us and share his knowledge. And without taking much time, I would request Sir to share his insights on this particular topic. Over to you, sir.
Thank you very much. Good evening, friends. The topic for discussion this evening is Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. For the benefit of those who are not aware of the earlier enactments, I would like to tell you that earlier we had the Untouchability Act. Thereafter, it was amended as Protection of Civil Rights Act 1955. Rather, it was not amended, the title was changed as Protection of Civil Rights Act 1955. I do not know the position elsewhere in the country. Insofar as the state of Karnataka is concerned, the police, after the enactment of the Atrocities Act of 1989, very rarely invoke the provisions of the Protection of Civil Rights Act 1955. In a workshop I had in Mandya, a district headquarters in Karnataka, about 10 or 12 years back, I told the SP of the district that Protection of Civil Rights Act is not repealed by the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Maybe some offences overlap, but there are certain independent offences also. Therefore, it is high time that the police invoke the provisions of the Protection of Civil Rights Act also if they find that the offence falls within the ambit of that enactment. Of course, when he was the SP, I did find in a few cases the provisions of the Protection of Civil Rights Act also having been included. I am not dealing with the Protection of Civil Rights Act 1955. The reason is, in my days it was triable by a magistrate. Probably the situation is the same. Since hardly the provisions of that act are invoked, I have also not brushed up my knowledge with regard to the Act of 1955. We will confine our discussion this day to the Act of 1989, which has this as its title, the Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Act 1989. It is a piece of social legislation. Whenever any provision of the enactment calls for interpretation, in the sense that the provision is not very clear, courts would naturally lean in favor of an interpretation which serves the object of the enactment. This is the premise on which the court proceeds whenever it finds that a provision of the law requires an interpretation. This you may keep in mind. Now, we will take a few important definitions first and then go to the procedure to be followed with regard to the trial of the cases, provisions regarding anticipatory bail, and other aspects. The word atrocity is defined in section 2A as what? as an offense punishable under section 3. Therefore, unless you go to section 3, you will not be able to know the meaning of the word atrocity. What is that atrocity as defined under section 3? It is not actually defined under section 3. It is an offense punishable under section 3. Therefore, whatever offense is punishable under section 3 is an atrocity. What are those offenses? Now, section 3 has two subsections, 1 and 2. In subsection 1, we have clauses commencing from A to ZA. There are a few insertions also in between. So there are about 26 to 27 clauses. All those acts referred to in those clauses A to Z, A to ZA of subsection 1 of section 3 is an offense punishable under this act, and therefore it is an atrocity. Similarly, subsection 2 has seven subclauses. Of course, 5A is also included. Totally, it would be 8 subclauses. Acts referred to in these subclauses constitute an offense, and therefore, by section 2, they are also atrocities. The word atrocity as such is not defined. It is stated that it is an offense punishable under section 3 of the Act. Then we have a code that is cr.p.c, who is a dependent. There is one thing known as exclusive special court and special court. I will come to that later. With regard to the definition of a public servant, section 2 small bg says a public servant as defined under section 21 IPC, as well as any other person deemed to be a public servant under any other law for the time being in force, and includes any person acting in his official capacity under the central government or the state government. Another important definition is scheduled caste and scheduled tribes shall have the meanings assigned to them respectively under clause 24 and 25 of article 366 of the Constitution. Then we have the definition of the word victim. Means any individual who falls within the definition of the scheduled caste and scheduled tribes and who has suffered or experienced physical, mental, psychological, emotional, or monetary harm or harm to his property as a result of the commission of any offense under this Act, and includes his relatives, legal guardian, and legal heirs. Then we have one general definition which says words and expressions used but not defined in this Act and defined in the Indian Penal Code, the Indian Evidence Act, or the Code of Criminal Procedure, as the case may be, shall be deemed to have the meanings respectively assigned to them in those enactments. Therefore, whenever a question arises as to what is the meaning to be attached, you will have to necessarily look to IPC, cr.p.c, and Evidence Act if those expressions are also found therein. Otherwise, the expression will have a meaning given under this Act. Straight away, I will deal with one aspect of the matter. The Act says a person is a scheduled can be said to belong to scheduled caste or scheduled tribe, and the meaning given is clause 24 and clause 25 of article 366 of the Constitution. One question would arise. Supposing a person who belongs to scheduled caste or scheduled tribe gets himself or converted to a different religion altogether, will he or she cease to be a victim under the enactment? By birth, he or she is a person belonging to scheduled caste or scheduled tribe. Later, converts himself or herself to Christianity, or any other religion for that matter. Whether by such conversion can she be said to have lost NPC be said to be not a victim under this Act? This has been covered by a decision of the Supreme Court, a 3-judges decision in State of Kerala versus Chandra Mohanan. State of Kerala versus Chandra Mohanan, reported in AER 2004 Supreme Court 1672. AER 2004 Supreme Court 1672. Para 5 of the judgment. The question as to whether a person is a member of the tribe or has been accepted as such, despite his conversion to another religion, is essentially a question of fact. A member of a tribe, despite his change in the religion, may remain a member of the tribe if he continues to follow the tribal traits and customs. If he is considered to be a member of the scheduled caste, he has to be accepted by the community. Then in para 20, the legal position is summarized. We therefore are of the opinion that although as a broad proposition of law, it cannot be accepted that merely by change of religion, person ceases to be a member of scheduled tribe, but the question as to whether he ceases to be a member thereof or not must be determined by the appropriate court, as such a question would depend upon the facts of each case. In such a situation, it has to be established that a person who has embraced another religion is still suffering from social disability and also following the customs and tradition of the community to which he earlier belonged. Now, let us take a case where the prosecution lodges the charge sheet on the ground. Yes, the victim in the case is a person belonging to scheduled caste or scheduled tribe. The accused states a defense that X has converted himself to some other religion. He is no longer a person belonging to scheduled caste or scheduled tribe. Here he has admitted that at one point of time he belonged to scheduled caste or scheduled tribe. He has changed the religion itself. By such stand alone, the prosecution case will not fail. Even after such conversion, has he suffered that disability? Did the disability continue even after such conversion? It is a question of fact, and therefore a defense in such a vacuum would not help the accused in any way, nor weaken the case of the prosecution. Now, we have seen some important definitions. We have seen the effect of conversion. Of course, which are those offenses? I will take it up at the end because there are a number of offenses. Nobody can remember it. I will just give a cursory glance to it. We will first, anyway, any prosecution starts with investigation first. I usually say this. There are 3 persons involved in a criminal case. One is the cook, that is the police, that is the investigating officer. He prepares the food. Other is the person who serves the food, that is the public prosecutor. He serves the food prepared by the investigating officer. Third is the person who eats the food, that is the judge. What is the role of the defense there? The defense lawyer would caution the judge saying that the food prepared by the investigating officer and served by the public prosecutor is not all that healthy, not all that tasty. Be a little careful before you consume the entire lot. He puts the court on guard. That is what the court is required to appreciate in the case of the prosecution can be taken at its face value, or is there anything which needs to be eschewed. This is not just common, this is not peculiar to the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act. That is the position with regard to any offense under any other enactment. So we will see who can investigate. This is a very important thing. Now, as usual, like in any other enactment which provides for framing of rules, Section 23 of this Act also empowers the central government to frame rules for carrying out the purpose of this act. Accordingly, we have the 1995 rules called the Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Rules 1995. I repeat, Scheduled Caste and Scheduled Tribes, within brackets, Prevention of Atrocities Rules 1995. Rule 7 speaks of this. Who can be an investigating officer? An offence committed under this Act shall be investigated by a police officer not below the rank of a deputy superintendent of police. This is the mandate of law. The investigating officer under this Act should be a police officer who is not below the rank of a DYSP. The investigating officer shall be appointed by the state government or the Director General of Police or the Superintendent of Police, who, after taking into account his past experience, sense of ability and justice to pursue the implications of the case and investigate it along the right lines within the shortest possible time. All and sundry cannot be appointed as investigating officers merely because he is a police officer of the cadre of DYSP. It is the state government or the DGP or the SP who appoints such an investigating officer. While doing so, what is it that the appointing authority has to take into consideration? The past experience of the proposed investigating officer, his sense of ability and justice to pursue the implications of the case, and ability to carry on the investigation on right lines within the shortest possible time. These things will have to be kept in view while appointing an investigating officer under this Act. What is it that the investigating officer so appointed is required to do? That takes us to Sub-Rule 2. The investigating officer so appointed under Sub-Rule 1 shall complete the investigation on top priority, submit the report to the Superintendent of Police, who in turn shall immediately forward the report to the Director General of Police or Commissioner of Police of the state government, and the officer in charge of the concerned police station shall file the charge sheet in the special court or the exclusive special court within a period of 60 days. The period is inclusive of investigation and filing of the charge sheet. The delay, if any, in investigation or filing of charge sheet in accordance with Sub-Rule 2 shall be explained in writing by the investigating officer. Here I stop for a while and digress a little. There are many enactments which require investigation to be completed within a given time and final report is filed. There is some confusion in the legal fraternity that is the time limit for taking cognizance. There are two different things. An obligation is cast on the investigating officer to complete the investigation in a given time. Of course, as far as the present enactment is concerned, he is also required to give an explanation in writing as to why there was that delay. Many enactments have such a provision. Take it from me, that is not the time limit for the court to take cognizance. That takes us to the provisions of cr.p.c. unless the special enactment itself says, notwithstanding anything contained in the Criminal Procedure Code, no court shall take cognizance of an offence if the final report is filed after a particular time. That is not the purport of any enactment. So taking cognizance is under the domain of the Criminal Procedure Code, whereas submission of a charge sheet within a given time is this. So let there be no confusion about this. Merely because the charge sheet is not filed within the time limited, within the time provided by this enactment, that cannot be a ground to say that the court cannot take cognizance. What does it say? Shall submit the report to the police, who in turn shall do it within a period of 60 days. So merely because the charge sheet is not filed within 60 days, it will not preclude the court from taking cognizance. That takes us to section 468 cr.p.c. That takes us to the offense that tells if the offense is punishable with fine, 6 months is the period of limitation. If it is punishable for a term not exceeding 1 year, 1 year. If it is more 1 year and more but not exceeding 3 years, 3 years. If it is anything beyond 3 years, there is no period of limitation at all. So therefore, let us not confuse this aspect of limitation with the requirement of law that the investigating officer should submit the charge sheet within a given time. What is the consequence of failure of the investigating officer to submit the final report within time? I think the department takes care of that. Court will not look into it. The court will see whether the charge sheet is presented within the time provided by the Criminal Procedure Code. Then, please go to section 9 of the Act. We are on the aspect of investigation. Who can be the investigating officer? Section 9 is equally important. Conferment of powers. Notwithstanding anything contained in the code or in any other provision of this Act, the state government may, if it considers it necessary or expedient so to do, for the prevention of and for coping with any offense under this Act, or for any case or class or group of cases under this Act, in any district or part thereof, confer by notification in the official gazette on any officer of the state government the powers exercisable by a police officer under the code in such district or part thereof, or as the case may be for such case or class or group of cases, and in particular, the powers of arrest, investigation, and prosecution of persons before any special court. All officers of police, and that's not necessary for us. So, Rule 7 of 1995 rules requires that the investigating officer shall be a person not below the rank of DYSP. But Section 9 says that the government for a given case may appoint any police officer for investigation. For a group of cases it can do, in a particular district it can do. In this regard, two decisions of the Supreme Court are in place. The first one of them is in State of Bihar versus Anil Kumar. State of Bihar versus Anil Kumar, reported in AER 2017 Supreme Court 272716. AER 2017 Supreme Court 2716. Now, the Bihar, in that case, being empowered by Section 9, the state government had entrusted the power of investigation to an officer not below the rank of Deputy Superintendent of Police, and therefore, ultimately the Supreme Court held that the state government had power to invest the power of investigation to any officer below the cadre of a DYSP, and therefore there was nothing wrong in that. Now, a latest decision of the Supreme Court may also be perused. 2020, 2 SCC 577. 2020, 2 SCC 577. State of Madhya Pradesh versus Babbu Rathore, BABBU, Babbu Rathore. You see, in this case, what happened was, rules were framed. Rules had been framed, and a notification was also issued empowering the power to investigate offences under this Act with effect from a particular date. But the offence in question had taken place prior to the date on which this notification was issued. Ultimately, the Supreme Court said, along with the offences under the along with the offences under the Act, certain offences under IPC were also included in the charge sheet. Therefore, the Supreme Court said that though in respect of the offence under the Act, the court cannot proceed because investigation was done by a police officer below the rank of DYSP and the notification was later. In respect of IPC offences, there is absolutely no bar to go ahead with the matter. And in this decision of 2022 SCC 577, an earlier decision reported in 2009, 12 SCC 649, 2009, 12 SCC 649, State of Madhya Pradesh versus Chunni Lal has been referred to and followed. Please go to section 14 of the Act. Special court and exclusive special court. This exclusive special court is by way of an amendment which came into force in the year 2016. Earlier, there was only a special court. For the purpose of providing for speedy trial, the state government shall, with the concurrence of the Chief Justice of the High Court by notification of the official gazette, establish an exclusive special court for one or more districts. That means no other case can be assigned to that court, only cases under the Act. Provided that in districts where less number of cases under this Act is recorded, the state government shall, with the concurrence of the Chief Justice of the High Court by notification of the official gazette, specify for such districts the Court of Session to be a special court to try the offences under this Act. So therefore, other cases can be assigned to the special court. As far as the exclusive special court is concerned, other cases cannot be assigned. If there are more cases in a particular area, an exclusive special court will have to be established. Elsewhere, special courts will have to be established. I said a special court is to be presided over by a judge of the cadre of sessions judges. A court of session has to be designated as a special court. All of you know that a court of session cannot take cognizance directly unless the case is committed to that court by the judicial magistrate of first class or the chief judicial magistrate, as the case may be. Kindly refresh your memory by going to section 193 cr.p.c. 193. Except as otherwise provided, expressly provided by this code or by any other law for the time being in force, no court of session shall take cognizance of any offence as a court of virginal jurisdiction unless the case has been committed to it by a magistrate under this code. A court of session, in view of section 193 cr.p.c, cannot directly take cognizance of an offence. The magistrate has to commit the case. It is only thereafter the court of session will take cognizance. To my knowledge, in the state of Karnataka, at least if not elsewhere, sometime back, charge sheets used to be directly filed in the special court. What happened was, in Gangula Ashok versus state of Andhra Pradesh, Gangula Ashok versus state of Andhra Pradesh, reported in AER 2000 SC 740, AER 2000 SC 740, the Honorable Supreme Court held that in view of section 193 cr.p.c, a special court being a court of session could not take cognizance directly unless the case was committed to it by the judicial magistrate. The result, therefore, was, even though the case had reached the stage of arguments before the special court, the records were sent back to the jurisdictional magistrate with a direction to formally pass an order of committal. That obviously caused a delay And therefore, in the state of Karnataka, an amendment was brought to section 14 saying the special court can take cognizance under this act as a court of original jurisdiction. That amendment is of the year 2003, Karnataka Act number 35 of 2003. Karnataka brought about that amendment. Other states might have brought about that. I am not very sure. Anyway, we need not now worry because now there is a specific provision under the 2016 amendment, that is the second proviso to subsection 1 of section 14. Second proviso to subsection 1 of section 14, provided further that the court so established or specified shall have power to directly take cognizance of offences under this act. Therefore, FIR can be submitted directly to the special court. Final report can also be submitted directly to the special court. This is being followed in the state of Karnataka. I will read section 14 again. For the purpose of providing for speedy trial, the state government shall, with the concurrence of the Chief Justice of the High Court by notification in the official gazette, establish an exclusive special court. First proviso I have already read, that is, a special court can be established. Then the second proviso I have read. Subsection 2. It shall be the duty of the state government to establish adequate number of courts to ensure that cases under this act are disposed of within a period of 2 months as far as possible. Subsection 3. In every trial in the special court or the exclusive special court, the proceedings shall be continued from day to day until all the witnesses in attendance have been examined, unless the special court or the exclusive special court finds the adjournment of the same beyond the following day to be necessary for reasons to be recorded in writing. We have a similar provision under the Criminal Procedure Code, section 309. Provided that when the trial relates to an offence under this act, the trial shall, as far as possible, be completed within a period of 2 months from the date of filing of the charge sheet. Just as there is a mandate to the investigating officer to complete the investigation within a period of 60 days, there is a similar mandate to the special judge also to complete the trial within a period of 2 months. Now, one question would arise. We have, under the Prevention of Corruption Act, a specific provision which says that a special judge under the Prevention of Corruption Act can, along with the offences under the Act, try offences under other laws also. There is an offence of forgery, misappropriation, and other things. So, charge sheet is filed against a public servant, not only for an offence under the Prevention of Corruption Act, but also for certain other offences under IPC or any other law. There is a specific provision in the Prevention of Corruption Act which empowers the special judge to try other offences also while trying an offence under the Prevention of Corruption Act. There is no specific provision under the Act which we are discussing today, which says that the special court can also try offences under other enactments if, along with the offence under the Act, charge sheet is laid for other offences also. I am not aware of any decision of any other High Court or the Supreme Court, but way back in the year 1995 itself, Karnataka High Court had an occasion to examine this question. In State of Karnataka versus Nagappa, State of Karnataka versus Nagappa, reported in ILR 1995 Karnataka 1361. ILR 1995 Karnataka 1361. The Honorable High Court held that the special court under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act can also try other offences if in the charge sheet offences under other laws are also included along with the offences under this Act. In particular, a famous judgment at the Supreme Court in A.R. Antole versus Ramdas in AR 1984 SC 718 has also been referred in that ILR 1995 Karnataka 1361. Then 14A is important. Appeals. Notwithstanding anything contained in the Code of Criminal Procedure, an appeal shall lie from any judgment, sentence or order, not being an interlocutory order of a special court or an exclusive special court to the High Court both on facts and on law. Under the Criminal Procedure Code, an appeal can lie only against certain orders, certain sentences, certain judgment of conviction or acquittal. It's specified there. Beyond that, no appeal lies. But under 14A of this enactment, any order which is not an interlocutory order, any judgment, sentence or order is appealable to the High Court. Subsection 2. Notwithstanding anything contained in subsection 3 of section 378 cr.p.c, an appeal shall lie to the High Court against an order of the special court or the exclusive special court granting or refusing bail. Whether bail is granted or refused, an appeal lies under section 14A. What's the normal position? If the magistrate does not grant bail under 437, an independent bail petition is filed under 439 in the Court of Sessions. And if the Court of Sessions does not grant bail under 439, an independent bail petition under 439 is filed before the High Court. But as far as this enactment is concerned, if bail is refused or granted, an appeal lies under section 14A to the High Court. Notwithstanding anything contained in any other law for the time being in force, every appeal under this section shall be preferred within a period of 90 days from the date of the judgment, sentence or order appealed from. So limitation is 90 days, provided that the High Court may entertain an appeal after the expiry of the said period of 90 days, if it is satisfied that the appellant has sufficient cause for not preferring the appeal within the period of 90 days. Provided further that no appeal shall be entertained after the expiry of the period of 180 days. So maximum is 180 days, 90 days statutory limit, then condonation of delay by another 90 days. Every appeal preferred under subsection 1 shall, as far as possible, be disposed of within a period of 3 months from the date of submission of the appeal. So therefore, there is no question of an application under section 5 of the Limitation Act for condonation of delay. The application has to be under the proviso to section 14A, the second proviso to section, first proviso to section 14A of the Act to condone the delay in filing any appeal. Then there is one important amendment brought to this enactment by Act number 1 of 2016 with effect from 26/1/2016. It is Chapter 4A, Rights of Victims and Witnesses. Chapter 4A has one section, section 15 capital A. This section 15 capital A has 12 subsections. I don't read all of them. I will read 1 or 2 only because it takes a good lot of time to read all that. Only important thing I will read. Section 15A. It shall be the duty and responsibility of the state to make arrangements for the protection of victims, their dependents and witnesses against any kind of intimidation or coercion or inducement or violence or threats of violence. Subsection 2. A victim shall be treated with fairness, respect and dignity, and with due regard to any special need that arises because of the victim's age or gender or educational disadvantage or poverty. Third is important. Subsection 3 is important for practicing lawyers and also judges and bail public prosecutors. A victim or his dependent shall have the right to reasonable, accurate, and timely notice of any court proceeding, including any bail proceeding, and the special public prosecutor or the state government shall inform the victim about any proceedings under this Act. So it is the duty of the public prosecutor also to inform the victim or his dependent that a bail application is moved and that it is coming up for hearing. Subsection 4. A victim or his dependent shall have the right to apply to the special court or the exclusive special court, as the case may be, to summon parties for production of any documents or material, witnesses, or examine the persons present. The normal rule is that it is the public prosecutor who is in charge of the case, and it is the prosecution which takes up all responsibility. Under this enactment, the victim or the dependent has a right to apply to the special court for summoning documents, material objects, and witnesses. Subsection 5. A victim or his dependent shall be entitled to be heard. Subsection 3 says he is entitled to have notice of the bail application. Subsection 5 says he or she is entitled to be heard at any proceeding under this Act in respect of bail, discharge, release, parole, conviction, or sentence of an accused, or any connected proceedings or arguments, and file written submission on conviction, acquittal, or sentencing. Under the provisions of cr.p.c, a victim can engage a lawyer, but that lawyer can only assist the public prosecutor. He can't argue the matter on his own. But that restriction is not here. Here, the victim is entitled to be heard at any proceeding in respect of bail, discharge, release, parole, conviction, sentence, or any connected proceedings, file written submissions on conviction, acquittal, or sentencing. Then, subsection 4. Notwithstanding anything contained in the Code of Criminal Procedure, the special court or the exclusive special court trying a case under this Act shall provide to a victim, his dependent, informant, or witnesses complete protection to secure the ends of justice, traveling and maintenance expenses during investigation, inquiry, or trial, social, economic rehabilitation, etc. Subsection 7. The state shall inform the concerned special court or the exclusive special court about the protection provided to any victim or his dependent. So, there are a number of such provisions which provide for, and subsection 10 is important. All proceedings relating to offences under this Act shall be video recorded. Then subsection 11 says, free copy of the FIR has to be given. Then immediate relief in cash or in kind to the victims of the atrocity. Necessary protection has to be given to the victims. So a big list of do's and don'ts is given in subsection 11 of section 15A, which as and when an occasion arises, you will read for yourself. Then we will go to section 7. Forfeiture of property of certain persons. Where a person has been convicted of any offense punishable under this chapter, the special court may, in addition to awarding any punishment, by order in writing declare that any property, movable or immovable, or both, belonging to the person which has been used for the commission of that offense shall stand forfeited to the government. Of course, we have provisions in cr.p.c also for forfeiture, confiscation, and all that. There is a special provision here. The property of the accused can be forfeited. Property of the accused which has been used for the commission of the offense shall stand forfeited to the government. It is mandatory. May, in addition to awarding any punishment, by order in writing that it shall stand forfeited. Then, where any person is accused of any offense under this chapter, it shall be open to the special court trying him to pass an order that all or any of the properties, movable or immovable, or both belonging to him, shall during the period of such trial be attached. During the period of trial, it can be attached. And where such trial ends in conviction, the property so attached shall be liable to forfeiture to the extent it is required for the purpose of realization of any fine imposed under this chapter. So for realizing the fine amount, it is necessary to sell the property which is attached. Then section 10 is another provision with which the special court is concerned. Removal of person likely to commit an offense. It is like a preventive measure. The court normally steps in after the offence is committed and after the final report is filed. But here there is a preventive measure. Normally that preventive measures are invested in the executive magistrates. But under this enactment, a court also enters the scene even before the submission of the charge sheet. But of course, not submission of the charge sheet, but it is like even before the trial, let me correct myself. Where the special court is satisfied upon a complaint or a police report that a person is likely to commit an offence, see that, he is likely to commit an offence. I didn't stand corrected, he is likely to commit an offence. Under Chapter 2 of this Act, in any area included in scheduled areas or tribal areas as referred to in Article 244 of the Constitution, or any area identified under the provisions of Clause so and so of subsection 2 of 21, it may by order in writing direct such person to remove himself beyond the limits of such area by such route and within such time as may be specified in the order, and not to return to that area from which he was directed to remove himself for such period not exceeding 3 years as may be specified in the order. These powers of externment order generally lie with the executive magistrate, but this is an enactment where such powers are given to the judiciary also. The special court shall, along with the order under subsection 1, communicate to the person directed under that subsection the grounds on which such order has been made. The special court may revoke or modify the order made under subsection 1 for the reasons to be recorded in writing on the representation made by the person against whom such order has been made or by any other person on his behalf within 30 days from the date of the order. Limitation is 30 days. Then 11 is also important. Procedure on the failure of the person to remove himself from area and enter thereon after removal. If a person to whom a direction has been issued under section 10 to remove himself from any area fails to remove himself as directed, or having so removed himself enters such area within the period specified in the order, otherwise than the permission in writing of the special court under subsection 2, the special court may cause him to be arrested and removed in police custody to such place outside such area as the special court may specify. So if he re-enters without the permission of the special court may direct the police to arrest him, bring him under police custody, and then send him outside that area. The special court may, by order in writing, permit any person in respect of whom an order under section 10 has been made to return to the area from which he was directed to remove himself for such temporary period and subject to such conditions as may be specified in such order, and may require him to execute a bond with or without surety for the due observation of the conditions imposed. Special court may at any time revoke any such permission. So if he has misused the permission, that permission can also be revoked. Any person who with such permission returns to the area from which he was directed to remove himself shall observe the conditions imposed, and at the expiry of the temporary period for which he was permitted to return, or on the revocation of such permission before the expiry of such temporary period, shall remove himself outside such area and shall not return thereto within the unexpired portion specified under section 10 without a fresh permission. If a person fails to observe any of the conditions imposed or to remove himself accordingly, or having so removed himself enters or returns to such area without fresh permission, the special court may cause him to be arrested and removed in police custody to such place outside such area as the special court may specify. What I am trying to emphasize is the special court doesn't step in only after the FIR is submitted or the charge sheet is submitted. Even otherwise, even before the trial, special court has got certain powers under section 10 and 11, which you will kindly read when an occasion comes. Section 12. Every person against whom an order has been made under section 10 shall, if so required by the special court, allow his measurements and photographs to be taken by a police officer. If any person referred to in subsection 1 required to allow his measurements or photographs to be taken, resists or refuses to allow his taking of such measurements or photographs, it shall be lawful to use all necessary means to secure the taking thereof. He can't claim protection under Article 20 here. Resistance to or refusal to allow the taking of measurements or photographs under subsection 2 shall be deemed to be an offence under section 186 of the Indian Penal Code. Where an order under section 10 is revoked, all measurements or photographs taken under subsection 2 shall be destroyed or made over to the person against whom such order is made. Any person contravening an order of the special court made under section 10 shall be punishable with imprisonment for a term which may extend to 1 year and with fine. So these are certain powers of a special court apart from the powers of holding a trial and punishing the accused. Now, as I said, will be taking up the various offences under the Act at the end. I am now on certain other aspects. The provisions regarding anticipatory bail and then whether a preliminary inquiry has to be held, these are certain important issues that need to be discussed now. Perhaps some of you may be knowing that the Honorable Supreme Court in Dr. Subhash Kashinath Mahajan, Dr. Subhash Kashinath Mahajan versus State of Maharashtra and another, reported in 2018, 6 SCC 454, 2018, 6 SCC 454, gave certain directions. It said that before registration of a case, a preliminary inquiry has to be done. If it is the arrest of a public servant, if it calls for arrest of a public servant, his official superiors should be informed and all that. The state sought a review of this judgment, and that is reported in 2020 4 SCC 761. 2020 4 SCC 761, Union of India versus State of Maharashtra. The earlier judgment in which it was held that a preliminary inquiry had to be held was by 2 judges. This Union of India versus State of Maharashtra 2020 4 SCC 761 is by 3 judges. The judgment was reviewed and it was held that preliminary inquiry was not contemplated except in cases specified in that famous Lalita Kumari's case. And the Supreme Court also observed that indirectly this decision in Dr. Subhash came in the way of the implementation of section 18, which bars grant of anticipatory bail. So this is another important decision which we will have to follow. Now, let us read section 18 first. Nothing in section 438 of the code shall apply in relation to any case involving the arrest of any person on an accusation of having committed an offence under this Act. A plain reading of section 18 indicates that there is a bar for granting anticipatory bail to an accused, to a person accused of an offence under this Act. We will see how the courts have interpreted a little later. Let us first understand the statutory provisions. Section 18 is a clear bar for granting anticipatory bail. 18A came to be inserted in view of the judgment in Dr. Subhash Kashinath Mahajan's case. In fact, it was the Act itself was amended by Act number, the Act was amended by Act number 27 of 2018 with effect from 17, it was brought into force on 28, 2018. The Act number is 27 of 2018. The statement of objects and reasons reads like this. In a recent judgment, the Supreme Court has held that a preliminary inquiry shall be conducted by a DYSP to find out whether the allegations made out a case under the said Act before registering a first information report relating to commission of an offence and the approval of an appropriate authority should be obtained before arrest of any person in connection with such offence. So, in view of this judgment of the Honorable Supreme Court, by Act number 27 of 2018, certain amendments were brought, and section 18A is one insertion consequent upon that amendment. We will see what that section 18A is. 18A subsection 1. For the purposes of this Act, a preliminary inquiry shall not be required for registration of a first information report against any person, or the investigating officer shall not require approval for the arrest, if necessary, of any person against whom an accusation of having committed an offence under this Act has been made, and no procedure other than that provided under this Act or the court shall apply. Subsection 2. The provisions of section 438 shall not apply to a case under this Act, notwithstanding any judgment or order or direction of any court. Therefore, a combined reading of section 18 and 18A subsection 2 would indicate that anticipatory bail is out of place in view of the provisions themselves. Now, let us see how the court has interpreted this provision from time to time. We have that famous Vilas Pandurang Pawar versus State of Maharashtra, reported in AER 2012 SC 3316. AER 2012 SC 3316. Its SCC equivalent is 2012 8 SCC 795. 2012 8 SCC 795. I am reading para 8 and 9 of this statement. Section 18 of the SC/ST Act creates a bar for invoking section 438 of the code. However, a duty is cast on the court to verify the averments in the complaint and to find out whether an offence under section 31 of the Act has been prima facie made out. In other words, if there is a specific averment in the complaint, namely insult or intimidation with intent to humiliate by calling with caste name, the accused persons are not entitled to anticipatory bail. Para 9. Scope of section 18 of the Act read with 438 is such that it creates a specific bar in the grant of anticipatory bail. When an offence is registered against a person under the provisions of the Act, no court shall entertain application for anticipatory bail unless it prima facie finds that such an offence is not made out. Moreover, while considering the application for bail, scope for appreciation of evidence and other material and record is limited. Court is not expected to indulge in critical analysis of the evidence on record. When a provision has been enacted in the Special Act to protect the persons who belong to the scheduled caste and scheduled tribes, and a bar has been imposed in granting bail under section 438, the provisions of the Special Act cannot be easily brushed aside by elaborate discussion on the evidence. This is a decision which was cited frequently by the prosecution. This decision was subsequently followed in Bachchu Das versus State of Bihar. Bachchu Das versus State of Bihar, reported in 2014, 3 SCC 471. 2014, 3 SCC 471. In this case, after referring to this decision in Vilas Pandurang, it is said, if no prima facie case is made out, then anticipatory bail can be granted. If prima facie case is not, if a prima facie case is there, anticipatory bail has to be refused. In fact, the order of the High Court granting anticipatory bail was set aside not only in Pandurang Vilas case, but also in this Bachchu's case. Then we have 2014, 15 SCC 521. 2014, 15 SCC 521. This is Shakuntala Devi versus Baljinder Singh. Shakuntala Devi versus Baljinder Singh. Again, following Vilas Pandran Pawar's case, order of High Court granting anticipatory bail was set aside. Then we have AER 2017 SC 1583. AER 2017 SC 1583. Manju Devi versus Wontarjit Singh Ahluwalia. AER 2017 SC 1583. Manju Devi versus Wontarjit Singh Ahluwalia. Order granting anticipatory bail by the High Court was set aside following Vilas Pandran Pawar. Then we have 2024 SCC 727. 2024 SCC 727. Prithviraj Chavan versus Union of India. Prithviraj Chavan versus Union of India, wherein it was held that if a complaint does not disclose a prima facie case, Section 18 is not a bar and arrest is not warranted. If no prima facie case is made out, 18 will not be a bar and arrest can be done. This decision in 2024 SCC 727 has been referred to in 2021 4 SCC 733, Rahana Jalal versus State of Kerala. Of course, the offence there was under this Muslim Women Protection of Rights on Marriage Act, but incidentally, the provisions of the Atrocities Act have also been referred to in that decision. Now, this is with regard to certain aspects regarding bail, anticipatory bail, the right of the victim to be present at the time of hearing the bail application, considering the bail application and all that. Now, let us have a quick look at the offense, various types of offenses under the Act. I am not taking you in detail for that because number of acts are considered as atrocities and they are all offenses under this Act. You can't remember them. As and when a charge sheet is filed, if you are the public prosecutor, go through the charge sheet, see the provision and see whether the ingredients are made out. If you are appearing for the accused, see whether those ingredients are made out and then argue. There is no point in reading this. I am only telling you, Section 3 has two subsections. Section 3, subsection 1 and subsection 2. The basic ingredients in all these cases is the accused should not be a person belonging to scheduled caste or scheduled tribe. The victim should be a person belonging to scheduled caste or scheduled tribe. That is the criterion. If the victim is a person belonging to some other caste, obviously the offense is not made out. If the accused himself is a person belonging to scheduled caste or scheduled tribe, then also the offense is not made out. This you will have to keep in view. Whoever not being a member of a scheduled caste or a scheduled tribe, a big list is given, commencing from A till ZA, a big list is given. Even in subclass ZA, there are other classes, capital A to capital D. It goes up to ZC. I said ZA, it goes up to ZC. Then subsection 2 again says, whoever not being a member of a scheduled caste or a scheduled tribe. One important amendment that is brought here is this. Before 2016, for certain offences, the requirement was that the accused committed that offence on the ground that the victim is a person belonging to scheduled caste or scheduled tribe. That mens rea was required to be made out by the prosecution. He did that act because the victim was a person belonging to scheduled caste or scheduled tribe. Now, that requirement is not there. Now it only says, commits any offence knowing that such person is a member of scheduled caste or scheduled tribe. This is important. Therefore, don't go by the earlier decisions which say that the prosecution has to establish that the accused did that act on the ground that the victim belonged to scheduled caste or scheduled tribe. Now, by this 2016 amendment, the only requirement for the prosecution is to show that the accused knew that the victim was a person belonging to scheduled caste or scheduled tribe. Then, as far as public servants are concerned, Section 4 says neglect of certain duties is an offense. Therefore, public servants also need to be very careful in doing this. Then we have Section 5, enhanced punishment for subsequent, in the case of subsequent conviction. One more important provision is required to be noticed under Section 6. It has said provisions of Section 34 and 149 IPC, that vicarious liability, common intention, and common object. Those provisions can be invoked for offences under this Act. Some offence under this Act read with Section 34 IPC, read with Section 149 IPC. So whoever shares that common intention, or whoever is a member of that unlawful assembly sharing that common object, is also liable to be punished. Then 8 is another provision which the courts, the public prosecutors, and the defense counsel need to know. In a prosecution for an offense under this chapter, that is chapter 2, if it is proved that the accused rendered any financial assistance to a person accused of or reasonably suspected of committing an offense under this chapter, the special court shall pursue unless the contrary is proved that such person had abetted the offense. So if the prosecution proves that the accused rendered any financial assistance to a person to commit that offense, then it has to be presumed that that person who rendered financial assistance abetted the offense. It is for him to rebut that presumption. I did not abet. A group of persons committed, if it is proved that a group of persons committed an offense under this chapter, and if it is proved that the offense committed was a sequel to any existing dispute regarding land or any other matter, it shall be presumed that the offense was committed in furtherance of the common intention or in prosecution of the common object. 8C is also important. In a prosecution for an offense under this chapter, if it is proved that the accused was having personal knowledge of the victim or his family, the court shall presume that the accused was aware of the caste or tribal identity of the victim unless the contrary is proved. See, there were some decisions which said that in the first information it was not mentioned that the accused knew that the person, that the victim belonged to scheduled caste or scheduled tribe. Now the amendment is, if the accused knew that person or his family, then it is presumed that the accused also knew of his caste or identity. This is another important provision which both defense lawyers, prosecutors, as well as judicial officers need to remember. Then Section 19 is yet another section which is important. It deals with non-applicability of the provisions of Section 360 cr.p.c or the Probation of Offenders Act. The provisions of Section 360 of the Code and the provisions of the Probation of Offenders Act shall not apply to any person above the age of 18 years who is found guilty of having committed an offense under this Act. Of course, if he is below 18, the Juvenile Justice Care and Protection of Children Act will take care of. Then, when it comes to compensation, if the offense is established, what's the legal position needs to be noticed. I find from my book, Section 357 cr.p.c has been amended by the states of Andhra Pradesh, Bihar, Goa, Karnataka, Madhya Pradesh, Rajasthan, Uttar Pradesh, West Bengal. Of course, my book gives this. Maybe other states might have also amended. Section 357 says, as per this amendment, if the victim belongs to a person belonging to scheduled caste or scheduled tribe, the court has to award some compensation in the event of conviction. Victim compensation is a subject by itself. Time is too insufficient to deal with the intricacies of section 357, which has two important subsections, 357 1 and 3, and we have another section 357A. I don't want to club it here, but just cursorily I will tell this. Under 357(1), if fine is a part of the sentence, out of the fine amount, some compensation can be given to the victim. Supposing I direct this accused to pay a fine of rupees 25,000. I can say out of this 25,000 rupees, 20,000 can be given as compensation to the victim. In fact, the entire fine amount can also be directed towards compensation. Under 357(3), if fine is not a part of the sentence, only imprisonment is the substantive sentence, then in addition to imprisonment, compensation can be given. There are a number of decisions giving the distinction between 357(1) and 3. This is not the occasion for me to tell it, nor there is time to do it. 357A is a provision which was inserted in the year 2009, Victim Compensation Scheme. Each state government is required to frame a scheme called the Victim Compensation Scheme. Some amounts are made available at the disposal of the state legal services authority to give compensation to the victims. 357A has a special feature. Under 357, the case has to necessarily end in conviction for the court to award compensation. But under 357A, even if the case ends in acquittal or discharge, if the court finds that the victim needs rehabilitation, it can make a recommendation to the legal services authority to award compensation. Needless to say, if the case ends in conviction and if the court comes to a conclusion that the victim needs rehabilitation, then a direction, then a recommendation has to be made to the legal services authority to give compensation. So, if a private complaint is filed for an offense under this Act, lawyers prosecuting that case may remember this. Even otherwise, as I have already pointed out, victim has a right to be heard. Therefore, if you are engaged as a lawyer for the victim, you should be aware of the provisions of section 357 and 357A and B. Apart from this, we have certain rules under the 1995 rules. Rule 12.4. Rule 12.4 of Scheduled Caste and Scheduled Tribes Prevention of Atrocities Rules 1995. The district magistrate or the subdivisional magistrate or any other executive magistrate shall make necessary administrative and other arrangements and provide relief in cash or in kind or both within 7 days to the victim of atrocity, their family members and dependents, according to the scale as provided in Annexure 1, read with Annexure 2 of the schedule annexed to these rules, and such immediate relief shall also include food, water, clothing, shelter, medical aid, transport facilities, and other essentials. So, Annexure 1 and Annexure 2, they will tell you what is the amount of monetary relief that can be given. Then, Rule 4A, for immediate withdrawal of money from the treasury so as to timely provide the relief amount as specified in Sub-Rule 4, the concerned state government or union territory administration may provide necessary authorization and powers to the district magistrate. 4B, the special court or the exclusive special court may also order socio-economic rehabilitation during investigation, inquiry and trial as provided in Clause C of subsection 6 of section 15A. Then Sub-Rule 5. The relief provided to the victim of the atrocity or his or her dependent under Sub-Rule 4 in respect of death or injury or rape or gang rape or unnatural offences or voluntarily causing hurt by use of acid, or voluntarily throwing or attempting to throw acid, etc., or damage to property, shall be in addition to any other right to claim compensation respect thereof under any other law for the time being in force. Therefore, even if so while awarding compensation under 357 or while recommending compensation under 357A, the court cannot say that the district magistrate has already given some compensation under Rule 10. So this is all what I intended to say about this enactment. Thanks, Mr. Vikas Chakra, for the opportunity. Any questions?
Yes, sir. Somehow the chat there's only one question, and it was disabled somehow, and I have not been able to restart.
Yes.
But on the YouTube we have.
Yes.
It says, is there any requirement of minimum number of witnesses, that to non-SC, ST, to prove an offense under this act?
No.
Okay. And this is by Manoj Karma. What is the punishment of lodging FIR under the SC/ST Act, though not ultimately found to be maintainable in the same?
The question is this: if ultimately it is not maintainable in the sense, there is no question of the FIR being not maintainable. If the FIR discloses commission of an offence under the Act, the investigating officer is bound to register it. Otherwise, he is also punishable under the enactment. Ultimately, after trial, if the court finds that the offence is not made out, then the accused will have to be acquitted. That's all. Nothing. And cr.p.c provides, if there is a case of wrongful arrest, then the accused can also be compensated, probably 300 and 1 minute. I will give the relevant provision. 359 cr.p.c also. It says, order to pay caution on 358, compensation to persons groundlessly arrested.
Then whether Supreme Court judgment of Ram Avatar versus State of MP can help of already going on ongoing writ petitions to pressurize that the FIR lodged under the SC Act will be treated as a civil matter and not under the SC/ST Act.
Not through the judgment.
Okay. Whether after the expiry of 2 months of the FIR is possible, if so, under what conditions?
No, the question is, as I already said, there is a requirement that the investigating officer should complete the investigation within 2 months. But that does not mean that the court is prevented from taking cognizance. Limitation for taking cognizance is bound by the provisions of cr.p.c. If the investigating officer is not able to complete the investigation in that period, he has to give reasons. Ultimately, if his official superiors find that deliberately has not completed the investigation within the given time, maybe departmentally he may be proceeded against. But cr.p.c does not come in the way of the court taking cognizance if the charge sheet is filed within the time provided there, and court also can condone the delay there under the relevant provisions of cr.p.c.
Okay. In case someone has filed a complaint under the SC/ST Act,
yes,
eventually it is found that the caste certificate is forged. As to then whether the atrocity case can be filed with false concocted ST Act, or what?
The question is, if the caste certificate is forged, then no offence is made out, the accused has to be acquitted. Whether the person against the person who has filed that complaint is to be prosecuted, that is to be seen for malicious prosecution, he may have to be prosecuted. That's all.
Okay. So these were the questions, and we are enriched. So somehow the questions have not come to that level, which normally does arise.
Because normally I used to speak on civil laws.
No, this was, as we discussed that day, this is a very niche area because there's not much in the law syllabus. Yes. Then there's not that much of litigation to that.
And only few advocates practice on the criminal side.
No, criminal side, your sessions on the criminal sides are doing extremely well. But this is a very niche area.
What I say, few advocates practice on the criminal side. Only a few advocates practice on the criminal side.
It's a very niche area, I'm saying.
Yes.
The cases are not to that level. So we can just have the last insights on 357 on victims' compensation, though we can take a session subsequently.
Okay.
357, what you were saying for 5 minutes, around 5 minutes, you can give them. Some explanation on 357.
See, 357 says, if the case ends in conviction and fine is imposed, say 50,000 rupees fine, the entire fine amount may be given as compensation to the victim of the offence, or a portion of the fine amount can be directed towards compensation. The remaining amount goes to the state. Under 357(3), if fine is not a part of the sentence, only if imprisonment is the sentence, along with imprisonment, compensation can also be given. For the applicability of section 357(1) or 3, the case should necessarily end in conviction. But as far as 357A is concerned, even if the case ends in acquittal or discharge, if the court thinks that the victim needs rehabilitation, then the court can make a recommendation. The court cannot fix the amount of compensation. It can make a recommendation to the legal services authority saying, though the case has ended in acquittal or discharge, the court is of the opinion that the victim needs rehabilitation. Therefore, I hereby recommend to the legal services authority to award compensation. The legal services authority has a committee of its own. The principal district judge, probably the chief judicial magistrate, public prosecutor, or some lawyer, they constitute a committee and they decide the quantum of compensation. And of course, if the case ends in conviction also, if the court is of the opinion that the victim needs rehabilitation, then certainly it can make a recommendation. Now, under the POTSO Act, the special judge can himself fix the amount of compensation. But in respect of other offences, the special judge, the court cannot fix the amount of compensation. It can only make a direct recommendation, not a direction to the legal services authority to do this. We have got number of decisions with regard to victim compensation. Of course, I have not brought them today.
No, that's fine. So since you have been doing a lot of threadbare bare acts and giving insights, we have done these sessions also with Mr. Udehola.
Yes,
what will be your advice to the lawyers and the students of law or professionals or judicial officers?
First, they should go through the bare acts.
No, to understand that also, how to understand.
To understand this is the reason. You see, for whatever reason it be, English has come to stay in the legal circles for historical reasons. Law is generally taught in English. Most of the enactments are in English. We don't have the translation to our mother tongue. Reported decisions are in English. Standard textbooks are in English. Therefore, unless you have a minimum command over the English language, it is difficult to understand the language of a statute. Therefore, my advice to the young lawyers is, first try to have some minimum command over the English language. If you read the enactment, you should pause where there is a comma. You should see whether there is a semicolon. They should see whether there is a proviso to the section, whether there is an exception, whether there is an explanation. Many times we only go by the marginal note to the section without going into the main part and thereby get confused. This is the problem with this. Now, with regard to 357(1) and 3 alone, it is very clear where fine does not form part of the sentence. It is very clear. So unless you read the section very carefully, don't start going through the decisions first. Read the enactment. If you still find it difficult to understand, then go through the commentary. Even when you go through the commentary, just don't read the commentary. There will be a footnote there which refers to some decision. Take that decision. Don't go by whether it is Mullah or Ratan Lal, he would have referred to some decision. It is not Mullah's opinion or Ratan Lal's opinion that matters. You will have to see as to what the judge has stated in that decision. That is how learning has to go on. It takes some time, but by experience, it's not so difficult to pick it up.
Okay, before we again part, since there are not many questions and we are used to have your sessions with this thing,
Yes.
Even in this section, how would you make the participants make to understand? How do they understand the proviso, explanation, marginal notes?
As I said, if the statute is in their mother tongue, there may not be much problem. Most of the enactments are in English. Courts, we are functioning in English. Of course, depositions are recorded in the local language. Judgments are mostly in English. My advice to the young lawyers is they should develop some command over the English language. They should read some newspaper, English newspaper every day, acquaint themselves. And if you go through the Bare Act, you will get that legal language, legal jargon. Thereafter, read some books, and then you will develop that. Unless you have a minimum command over the language, even if the statute is in Kannada or English or the local language, you will not be able to understand it. You will have to carefully go through it. Don't presume anything. The problem with most of us is we presume that there are certain things. As I said, the Atrocities Act has not repealed the Protection of Civil Rights Act at all. After this Atrocities Act came, I hardly could find a charge sheet where the Protection of Civil Rights Act was invoked, because we presume that this act has repealed it. It has not repealed it. The problem with us is we presume certain things before we go through it. This act of presumption we should first give up. Whether I tell it or somebody else tells it, even when I have said something, it is better for the participants to counter check it. Sometimes I might have spoken from my memory. They will have to counter check it. That's the correct way of learning.
And sometimes the law also evolves with the
Yes,
passage of time.
yes.
They say. So I was saying, for a common man to understand how do you understand the meaning of the proviso as such an explanation?
For a common man, it is difficult. Let me be very honest. For a common man, understanding the legal provisions, even if they are in mother tongue, it is difficult. That is my honest opinion.
That I also believe. That when we get the verification, and sometimes the court has of the opinion that the verification is not probable, is not in consonance. I always believe that he has not understood actually. He just believes that the lawyer, what he has got it written, must be correct.
As a joke, I can say, as a professional, you should be happy that the legislation is such that a common man cannot understand. He is forced to come to you. Be happy about it.
That's true. So thank you, sir, for sharing your knowledge. And
Yes.
it is always insightful. And tomorrow's session, like you were concluding on the POCSO Act, tomorrow we will be having a session of evidentiary standards in POCSO Act by Dr. Justice Shalini Fansaskar.
Oh,
So
very
she is
good.
a former judge who has recently written a book on this act. Therefore, we thought, why not come from a person who is well known on these fields, coupled with the fact he has recently brushed up the book also on the POCSO Act.
In fact, she also speaks on Juvenile Justice Act.
Yes, yes.
She is very good at Juvenile Justice Act also.
Yes, we have done sessions with her.
Yes, extremely good. Very
and
good.
His book is tomorrow, Decoding the Child. His book is otherwise Decoding the Child Sexual Abuse.
Yes.
Do stay connected with us tomorrow at 6 p.m. Thank you, everyone. Stay safe, stay blessed. Namaskar.